A district court struck down California's ban on large capacity magazines.
Your right to own a gun can also be restricted.
So Judge Benitez has issued his ruling, which found that California's magazine ban is indeed unconstitutional.
I think most of these laws with firearms in California, in this space, that's where they're going to be pushed.
Here's the amount of gun violence that has happened. I think we're reaching a tipping point where we're about to hit desensitization to gun violence.
After the state of California lost that original preliminary injunction, they then appealed that decision up to the Ninth Circuit.
We think the court got this decision dead wrong, and my office is immediately filing an appeal.
Mag ban ruling. In a recent pivotal decision, U.S. District Judge Roger Benitez ruled that California's ban on detachable mags capable of holding more than 10 rounds is unconstitutional. This marks the second time Judge Benitez has struck down this specific law. The initial ruling, issued in 2017, was subsequently overturned by an appeals court. However, recent shifts in how the U.S. Supreme Court interprets arm laws prompted a reevaluation of this case and others like it. The heart of the matter lies in California's attempt to impose restrictions on arm accessories, specifically detachable mags, exceeding a 10-round capacity. These mags, known for their potential to swiftly reload arms, have been a focal point in discussions regarding arm control measures. Advocates for stricter regulations argue that limiting mag capacity can mitigate the potential harm in mass slaying incidents, allowing for more rapid intervention by law enforcement and potentially saving lives. Following Judge Benitez's decision, California Attorney General Rob Bonta, a Democrat, promptly filed a notice of intent to appeal.
A district court struck down California's ban on large capacity magazines.
So Judge Benitez has issued his ruling, which found that California's magazine ban is indeed unconstitutional.
We think the court got this decision dead wrong, and my office is immediately filing an appeal.
As a result, the ban on high-capacity mags is expected to remain in effect during the ongoing legal proceedings. This implies that while the ruling marks a significant milestone, its immediate impact may be limited as the legal process advances. The recent shift in how the U.S. Supreme Court interprets arm laws played a crucial role in this case. The court established a new framework, emphasizing historical traditions of arm regulation over public interests, including safety considerations. This change in approach prompted a reevaluation of cases such as the one regarding California's mag restrictions. In light of the updated standards set by the U.S. Supreme Court, the case pertaining to California's ban on high-capacity mags was ordered to be reheard. This decision aligns with the broader trend of re-examining high-profile challenges to California's arm laws. Alongside the mag case, two other significant legal challenges are underway, one contesting California's restrictions on assault-style arms and another addressing limitations on ammunition purchases. In Swift, the recent decision by Judge Benitez marks a significant turning point in the ongoing legal discourse surrounding arm control in California. While it stands as a victory for proponents of less restrictive arm regulations, the case is far from concluded, with an imminent appeal and potential for further legal proceedings. The broader context of evolving Supreme Court interpretations and additional high-profile challenges underscores the dynamic nature of the legal landscape surrounding arm control in the U.S. Perspectives and implications. In a significant legal decision, U.S. District Judge Roger Benitez has ruled against California's ban on large-capacity arm mags, asserting that there is no established American tradition of limiting ammunition capacity. According to Judge Benitez, detachable mags serve a critical purpose in historic arms by addressing the challenge of reloading, ensuring a continuous supply of ammunition in defensive situations. He argued that there are instances where more than 10 rounds may be necessary to thwart attackers, but the state's statute effectively disregards this need. California Attorney General Rob Bonta countered Judge Benitez's decision, emphasizing the importance of restricting larger capacity mags to prevent mass slayings.
And therefore he has entered an injunction.
Your right to own a gun can also be restricted.
Issued his original order finding that the law was indeed a violation of the Second Amendment.
Bonta contended that such mags enable shooters to fire rapidly into crowds without the need for frequent reloads. He also cited the U.S. Supreme Court's position, asserting that the recent shift in interpreting arm laws does not constrain states but rather offers room for regulatory adjustments. Chuck Michel, president of the California Rifle and Arm Association, commended Judge Benitez for his thoughtful and thorough approach. Michel acknowledged that while the state may pursue an appeal, time may be running out for laws that potentially infringe on constitutional rights. California has been a trailblazer in implementing stringent arm control measures in the U.S. Recently, the state took a significant step by becoming the first to advocate for a constitutional amendment prohibiting assault arms and restricting arms sales to individuals under the age of 21, among other proposed changes. Governor Gavin Newsom expressed strong disagreement with Judge Benitez's ruling, characterizing it as a radical decision driven by political motivations. He argued that the ruling underscores the need to enshrine a right to safety in the Constitution to safeguard against ideological interpretations by judges like Benitez. This decision has sparked broader conversations about the balance between arm rights and public safety. It highlights the ongoing legal battles and ideological divides surrounding arm control in the U.S. The ruling also underscores the significance of judicial interpretations in shaping policies that govern arms. As the legal process continues, it will be essential to closely monitor the potential impact of this decision on California's arm laws and regulations. Additionally, the broader implications for other states grappling with similar issues will likely be a subject of ongoing debate. In supposition, Judge Benitez's recent ruling on California's mag ban has ignited a contentious debate on arm rights and public safety. The decision underscores the divergent viewpoints surrounding arm control in the U.S., with proponents advocating for constitutional protections and opponents emphasizing the need for measures to prevent mass slayings. The ultimate repercussions of this ruling will likely extend beyond California, influencing discussions and policies on arm regulation at both the state and federal levels. Analyzing the recent ruling, Judge Benitez confronts California's effort to reframe the dangerous and unusual test as the dangerous or unusual test, contending that mags capable of holding more than 10 rounds do not meet the criteria of being both dangerous and unusual. He asserts that while all arms and ammunition are inherently dangerous, mags with capacities over 10 rounds do not fit the unusual aspect, which constitutes the Supreme Court standard. Furthermore, Judge Benitez scrutinizes the new historical evidence presented by the state, especially in light of the Bruin decision. He highlights that many of the historical arguments had previously been rejected, but he allowed the state an opportunity to present fresh evidence. However, he ultimately finds that the additional arguments fail to convincingly support the ban. Notably, California's reliance on approximately 38 historical laws is dismissed, as they are deemed irrelevant to the current debate. A pivotal argument put forth by California is the analogy to the 1784 New York City arm powder storage law, which the state contends justifies the mag ban. Judge Benitez firmly rejects this comparison, asserting that the law primarily focused on fire safety and was unrelated to arm safety or arm control. This rejection weakens one of California's core claims, as the historical precedent invoked does not align with the goals of the mag ban. Ultimately, Judge Benitez concludes that California's mag ban is unconstitutional, echoing his previous stance. He grants an injunction against the enforcement of the ban, which, notably, will not take effect for another 10 days. In response, California promptly appealed the decision to the Ninth Circuit.
After the state of California lost that original preliminary injunction, they then appealed that decision up to the Ninth Circuit.
He's likely to overturn our weapons ban.
This law was challenged in a district court, and Judge Roger T. Benitez, or St. Benitez,
signaling that the legal battle is far from over. While this ruling marks a significant victory for those advocating for less restrictive arm regulations, it's important to note that the ban remains in place for the time being. The best-case scenario for those seeking to purchase mags with capacities exceeding 10 rounds would be October 2nd, when the stay imposed by Judge Benitez may be lifted. However, it's advised not to anticipate immediate changes, as legal proceedings often involve complex, protracted timelines. In conclusion, Judge Benitez's decision on California's mag ban exemplifies the ongoing debate over Second Amendment rights and public safety. The ruling dissects legal arguments, challenging historical evidence, and ultimately asserts that the ban infringes upon constitutional rights. As the legal process continues, it remains crucial to closely monitor developments and their potential implications for arm regulations in California and beyond. Public reaction. The public's response to the recent Supreme Court decision on the mag ban has been diverse and impassioned. Advocates for stricter arm control express concern over the potential implications for public safety. They argue that allowing high-capacity mags could potentially escalate the severity of mass slayings.
Here's the amount of gun violence that has happened. I think we're reaching a tipping point where we're about to hit desensitization to gun violence.
That then led to what is known as Freedom Week in the state of California,
and make it more challenging for law enforcement to intervene effectively. On the other hand, proponents of arm rights celebrate the decision as a victory for Second Amendment freedoms. They argue that it upholds the right of individuals to have access to arms and accessories without undue restrictions. Political responses. Politically, the decision has ignited a fresh wave of debate and action. California Attorney General Rob Bonta, a Democrat, swiftly filed an appeal, indicating the state's commitment to defending its arm control measures. This legal challenge represents a continuation of California's progressive stance on arm control and its determination to implement stricter regulations.
Nothing's going to change for the foreseeable future. And when I say that, I mean for years.
The Second Amendment to the United States Constitution, Mr. President, as you well know,
I think most of these laws with firearms in California in this space, that's where they're going to be pushed.
Additionally, other states and advocacy groups are closely monitoring the situation, as the decision could set a precedent with national implications. Nationally, the decision may also factor into the broader discussion on arm control laws and could potentially influence future legislative efforts at both the state and federal levels. It's likely that politicians with varying stances on arm rights and control will use this ruling as a point of reference in their respective campaigns and policy agendas. That's all for this video, folks. See you next time.